Great. Well, thank you again, everyone. So, as I was kindly introduced, my name is Alex Cosgrove. I'm a partner here at Bridges in the commercial team. I have been working in construction and projects for over 15 years now. And the purpose of this presentation really was just to give a bit of an overview in terms of the context of COVID, which is obviously everyone is familiar with, but some ideas about how we are now moving beyond that into new projects, new construction ventures, and how we might take some of the lessons learned away from the experiences of the past 6 months or so to either adapt the contracting strategy, so the approach taken to which contracts are entered into and how, but also particular more detail in terms of the specific provisions or risk allocation in the contracts, and just some sort of general guidance, I guess, around how to approach that, and some thoughts about how that might change now that, or at least need a revisiting now that we have this experience, and certainly the restrictions and the impacts of COVID aren't going anywhere anytime soon, unfortunately. So this is just a bit of background to me, but just to say, the kind of lessons in this presentation are based on quite a lot of practical experience advising on these matters. So just a general overview, I guess, to kind of contracting speak for those who need it. Obviously, COVID has had a big impact in terms of disruption, delay, and problems caused in the practical construction work. And that has then resulted in our clients either wishing to receive relief for the impacts that they've suffered, or being concerned about the claims that are being made against them by their contractors or their suppliers for the impacts that have hit them. And so by relief, we mean typically either a time relief, as in they seek to have an extension to the deadlines or the timetable required for completing certain activities because they need more time to do it because of an impact, or cost relief, in that it now is going to cost more to complete the activity, or there's been additional costs that they've had to incur to mitigate the impacts, and they want to seek recovery of that as well, because the original proposal was made on a certain timescale and at certain pricing, but the world has changed and they want to be kept in the same position as they would have been had it not happened. And when we talk about these kind of things in a contractual context, we talk about force majeure, which does not have a defined legal meaning, but it's the meaning given by the parties in the contract, but typically is a term used to mean events outside of a party's control that prevent or hinder the performance of activities or contractual obligations, and changes in law, i.e. that you contracted based on a certain legislative environment, a certain legal environment, and that has changed. So something that's happened since you signed that has changed the world. And for both of those, typically we're talking about who bears the risk of those happening and what kind of relief you can get if those occur to put you back into the position you assumed you were going to be in when you agreed to do the particular work. And obviously the focus when we look at those clauses in the context of COVID is, do they cover these circumstances that have actually arisen, and what do they say about what relief, if any, is available, and what obligations the parties have in those circumstances? Typically, you'll see things like notices that have to be given, mitigation efforts that have to be made, that kind of thing. And it's very obviously when we're advising in the current circumstance about in existing contracts of people that are actually being impacted, those things are critical to look at and make sure you comply with those. And we're obviously available for anyone who's actually suffering issues at the moment to help advise on analysing those. It is difficult, particularly in construction where there is a range of the different standard form contracts and it's always dealt with differently in different places. So there's just a note there to emphasise or give a bit of guidance. So under JCT, for example, these fall under the category of relevant events. And we'll come on to, I'll come on to in a little bit, how there's been recommended changes as a result of to the drafting of those provisions as a result of the lessons learned from COVID. But we'll come on to that in a little bit more detail. This is just a sort of a bit more of a general overview. And this talk's not really about current impacts and sort of the issues that people are facing under their existing contracts. Is more around what next, to try and be a little bit more positive, to say, well, clearly we're going to be entering into new contracts, doing new developments, and what are the lessons learned and how we can prepare for those. Now, one of the key lessons we found is it emphasizes the importance of having just clear contractual terms generally. It's a particularly an issue in the construction industry where you have standard terms, because most of the legal work is dealt with. You're just dealing with certain key commercial issues and particulars for a project, but it does increase the risk, we find typically, of there being gaps in that information. They're relied very much on the standard terms. It becomes a bit mechanical, and then when it actually comes to an issue, or we're asked to advise on whether or not relief is available to extend a particular deadline, the first issue we come across is that it's not clear what the deadline was. The completion date, for example, has not been completed or clearly. And the last thing you want when you're seeking a quick answer on whether or not you have a contractual right to a particular relief is to first have a disagreement about what the contract was originally meant to mean, what your original obligations were, because obviously we can't go on to talking about how those should be fairly adjusted until we know what the original position was. So it just sort of re-emphasizes, in a world where there is a greater risk of delay and impact, force majeure claims were a lot rarer a year ago than they are today. It just emphasizes that need to get off on the right foot with a clear and complete contract. And then on a more general perspective, it's true, I've put on the slide for employers, but actually it's true for contractors as well, for the larger contractors, certainly. With most projects, there's a decision to be taken in terms of contracting. Often there are different parcels of work that can be separated out between different contractors. And so one of the key decisions made early on is whether that is how the contracts are going to be divided up into multiple contractors that the employer will employ directly, or whether there's going to be a kind of a single point contractor appointed who will then have to subcontract as necessary, but you've got a single point responsibility. Now, from a risk perspective, the latter is better, is easier, because you don't have that finger pointing risk of one contractor suffers or the other contractor claims it's somebody else's fault, and you have to end up having to manage and deal with that. And there's a whole contracting managing job that comes from undertaking that arrangement or going into that arrangement. And so, but certainly it's cheaper. And so there's always been that balancing decision. And obviously certain employers and contractors have more in-house expertise for managing that, and and come to the conclusion based on the risk that they're comfortable with. But I suppose this is just a point to note that because of the heightened risk, it's worth reevaluating the degree of risk that you're willing to take on in that respect. And potentially it may be worth considering contract management solutions, or on certain projects, moving to a more single point contracting strategy, or reducing the number of contracts taken on, just to limit that risk. That's one approach to it. The other approach is simply to have a more detailed discussion with your counterparties to understand their vulnerabilities. It's a bit like we used to talk about in the context of carbon reduction, etc. It's the supply chain, and it's knowing who's involved in what steps they're taking to mitigate or to prevent impact. Because we know now what the current restrictions are, and we have a reasonable idea of the potential risks of future restrictions, regional lockdowns, or heightened restrictions. And so we're better educated now than ever in terms of what might be the impact in the future, and understanding how everyone involved in a particular project is or is not prepared for that. It also goes to the standard contracting recommendations that we make in terms of pass-through of risk, as I would describe it, in the sense of, if you are a contractor and you have contracted on particular terms, but you have employed a subcontractor for a particular piece of work, one of the key things to always look to is make sure that the risks that you and the obligations you've taken on to the employer are passed through appropriately to that subcontractor. And a simple example in this context is, if you have to give notice upon being impacted by a force majeure event, some sort of COVID restriction, does the subcontractor have to tell you in a period of time that is sufficient for you to pass that notice on to the employer? So it's a simple question, and it's true of contracting generally, but as I say, again, in a more heightened environment, it just puts emphasis on whether that's been done properly, because the chances of those notices being required are heightened. And if the notice periods haven't been adjusted appropriately, such that the contractor has more time to issue a valid notice than you do to claim the benefit of that against your main contract, then you're in trouble, because you'll get a valid notice. You have to give that relief to your subcontractor because they're entitled to it, but you're unable to back that off against your main contract because you've run out of time. And so that's a standard practice we do for all contracts, but as I say, it's something that's been heightened by this general environment. And with that knowledge and that understanding of your supply chain and your contractors, you can obviously try and do some more planning and try and prevent known impacts. I think that's probably all to say on that at the moment. The next section was really just about slightly more specific issues. So, as I say, it's clear that we're going to be living in this environment for some time, and with contracting generally, the approach is, if you have an issue that you know of and a risk that you're aware of, the number one purpose of the contract is to allocate it. So you agree contractually before you start who's bearing the risk of a particular event, and clearly allocating it. So as we'll come on to, and as I mentioned, how the risk of the pandemic was addressed wasn't clear enough under the current standard contracts, or could be clearer, perhaps I should say. Unsurprisingly, because it was never anything that anyone thought was particularly likely. And so, a starting point is when you are aware of something, we enhance the drafting to make sure it's clearly addressed, and then we have the commercial negotiation, discuss how that's going to be allocated. And that's not only the current risks and things we know about, but also potentially the unknown in terms of what happens if there's an additional restriction or a new pandemic and that kind of thing, and deciding to what extent, as I've mentioned before, contractually you should be obligated to have mitigation in place, or have plans and be required to implement those. And as always, the ideal is to allocate the risk to the party that's best able to control it. So in most cases, that's going to be the contractor, in the sense that they are the ones who will be practically doing the task, and so can best mitigate the risks. But then that has to be balanced against the kind of certainty that gives. Obviously, from an employer's perspective, it gives a lot of certainty if you can say everything COVID related is the contractor's fault. You just have to cope with it. We're going to keep you to your timetable and your cost pricing. It gives you certainty, but it doesn't come for free. And with every kind of issue, if you're requiring a party to bear risk that they can maybe control to a degree, but not entirely, it's going to be reflected in the cost and also in the timetable. So if you're pushing the risk of COVID and risk of future restrictions onto a contractor in that way, expect the timetable to have fat in it to allow for that, and some cost as well in case they can't recover the impact, in which case the employer is bearing that risk to a degree because they're paying for it up front. Whereas the alternative, which is typical for things that are not known at the time of signing, is that there'll be adjustments made at the time such that they're not priced in at the beginning. And that's all typical, but it's again more of a sort of emphasis that this sort of upfront thinking and discussion about issues that we know about, given that this was not an issue that was on people's regular negotiation list, is recommended, because who knows what will happen in the future, but we're certainly better educated about certain risks, and it's always worth talking them through beforehand. Now, in terms of actual drafting to address COVID and how we might approach things differently, the Construction Leadership Council has issued guidance on how this could be clarified in the standard form documentation, JCT, etc. And the approach that takes is to provide very broad definitions that very clearly define not only COVID as force majeure, but a wider definition of pandemic event, which will cover future pandemics as well. And it also covers legislative changes in relation to a pandemic, and its consequences that are outside of the control of the contractor, things that affect the works, the labor and the materials, etc. So provides a very clear statement that these matters are force majeure. These are matters that the contractor is entitled to relief for, and therefore focuses discussions entirely on what relief should be available. And it provides different options, and that's the focus on for the negotiation then, is whether or not it should just be time relief. So you're allowed a bit more time, but any extra costs have to be borne by the contractor, or time relief and some financial relief as well. And it proposes one option for negotiation is to only pay a percentage of the costs. So a kind of cost sharing exercise encourages the contractor potentially to mitigate some of the costs because it's not full recovery. So there's it's trying to balance a bit of incentive there to keep to utilize some of that control that I was talking about before the contractors have to potentially plan ahead, have some mitigation and reduce the costs, because if they're sharing those costs, albeit not 100%, they're shared, they're not being borne 100% by either party, then that helps encourage each party to do what they can to keep those under control. And then finally, if there's long-term impacts from force majeure, it's about the suspension relief, but also longer-term termination rights in case of prolonged force majeure. Because if it's clear that those aren't, the situation is not going to unlock itself anytime soon, allowing people to walk away. Now, that's great in a way from a contractor's perspective because it is simple. And from a negotiating perspective, again, it's simple because it focuses the discussion on relatively narrow grounds. But from an employer's perspective, it's potentially not ideal. And the reason for thinking along those lines is when you're an employer and you're going out to tender for contractors, you expect them to take into account the current known environment. As I said before, there's an argument to say contractors are best placed to mitigate the risk and to understand the risk, look through their supply chain, know their vulnerabilities, etc., and factor in the current known environment into the proposal. No employer wants a contractor to begin and then very early on claim extensions, etc., due to factors that the employer considered they should have been taken into account at the outset. So we're seeing in our contracts, in all sectors, not just construction, but a clear statement up front to say, the contractor is taking into account the current environment and will not be making claims in respect of known existing restrictions. But that's a kind of negotiated position, but it's just encouraging people to, or from an employer's perspective anyway, to potentially take a look at that blanket statement that everything for COVID is force majeure, and assessing whether that's appropriate in a particular contract. And the various options include limiting the scope of relief to only additional harsher restrictions than were in place at the point where either the contractor provided his tender or the date of signing, so that the conversation is only live in terms of additional restrictions. And in fact, as I mentioned, you can include particular specific confirmations in there from the contractor around having assessed the existing environment and proposed on that basis. But it can go further. And one way of improving certainty for an employer in terms of projects where there's particular cost sensitivity or timetable certainty, where certainty is a premium to other matters, for example, is to contractually require the contractor to have looked at its supply chain, its working practices, understand its contractors, and put in place plans which you could even attach to the contract and have as a sort of a mitigant to say, if these events arise, this is what you'll do, and it's just part of the contract. Or you could pre-agree, some middle ground might be to pre-agree the cost and time impact of those things. So it's again, trying to tie down with a bit more certainty what the impact would be. So it's not all bets are off and it'll take as long as it takes. It's, we've thought about this in advance and we've tried to keep the timetable impact to a minimum because of X, Y, Z, and that's what's agreed will happen. Again, because more is known now about what could happen, and it's encouraging people to use that knowledge to to not hide behind force majeure just as a blanket protection, and at least try and meet in the middle ground, I guess. So that's kind of the sort of takeaways I thought worth highlighting, and certainly hoping to project a sort of more positive outlook to say, you know, we are all moving forward with new projects, there's new contracts being negotiated, and how can we take the lessons away, but also draft those contracts in a way that you know, will be more robust in the future. So thank you all for that. I know it's a heavy topic, and hopefully that was kind of accessible to most, and certainly happy to take any questions. My email is on screen for, you know, for more detailed points, but if there's anything we can do with now, they're happy to do so.
That's brilliant, thank you. Does anyone have any questions at all? Feel free to unmute yourselves if you like, or put them in the chat.
Hello.
Hiya.
Martin Birch. I'm struggling from an employer's point of view, thinking in a JCT, you've got force majeure. Okay, there's costs from the pandemic, COVID-19 for the contractor, but then the employer's getting his project later and he's not charging damages. So is there a give and take there? Why should we change it?
So, well, why should you change it? From an employer's perspective, in terms of existing contracts, the idea is nobody knew before you signed that this was going to be an issue, and so force majeure is there to protect you against the unknowns. And so there is typically, and certainly under the JCT, no kind of risk sharing in terms of the delay from a force majeure event. That's just typically how these things, it's outside of everyone's control, so no one has to put their hand in their pocket. No, there's no damages, but equally you're not penalized, so there's time extensions. And what I'm saying is, from an employer's perspective now, knowing that these are known issues that you could say a contractor should be mitigating for, actually adding additional provisions into the contract to push that, to say you can't just claim force majeure relief because of a new pandemic, because it should be something you're prepared for now. And it should either be, you should have mitigations in place in your project schedule, you should have plans in place, having thought it through in advance so that you can recover and mitigate the impacts more quickly, and therefore reduce the impact on the timetable. And if you fail to deliver on those mitigations, then there will be delayed damages because it limits the amount of relief that you're entitled to. So typically, those negotiations have gone that contractors are still entitled to relief for new restrictions that come in place after signing, but making very sure that restrictions that are known today are not a ground for additional claims. So you don't get an extension time for that, because you should have factored that in.
Right.
So if that.
So in some ways, you say you're actually toughening it up a bit then. We
would say from the standard, we would suggest a toughening, actually, yes, because under the broad brush approach, there's a danger that you can get claims for matters that should, well, and it depends on perspective, obviously, but the employers think should have been taken into account, because we now know for new contracts, we now know what these restrictions are, and they should be taken into account. It's a bit like environmental restrictions. You know, they make things take longer, cost more time, but if we know they're in place, you should be working knowing that those are restrictions that you have to deal with.
Can I ask one more question? When will the JCT issue these amendments?
The task force has already issued them, so they are available.
They have they? Oh, right.
Yeah, the task force, yeah. We can share a link for that. I can perhaps put that in the chat.
When did they issue them?
That's a good question. I think they came out earlier this year, but it wasn't that long ago. I want to say June, July, but I'd have to check.
Okay, fair enough. It's a few months ago anyway. Yeah. Okay, thank you very much.